can I ask you to maybe address Justice Alito's question to Mr. Francisco a little more directly? Mr. Francisco said that the RNC and the DNC had long been aligned on this question, and normally regulated parties are happy to get rid of regulation. And obviously this ties the DNC's hands just as much as it ties the RNC's hands. So I guess my questions are two. One is, if the parties had long been aligned on this, why change the position? And two, if there isn't an imbalance in who this benefits, why would the DNC be here? Like, why would your client be here if it didn't perceive this to be something that would benefit the RNC more than the DNC?
Yeah, so I would correct my friend. I don't believe the parties have been aligned on this interest. I think the issue, I think that if you go back, in fact, I know since the very first brief my name ever appeared on before this court was in 1995 in Colorado 1. And you look at the position of the Democratic National Committee and the Democratic Senate and Congressional Campaign Committee, they did not say that the limits should be struck down. Their brief said essentially that the definition of coordination should be narrowed, but not that the limits entirely should be struck down. And we did not file a brief in support of the Republican Party in Colorado too. So I don't think that it's correct to say that our position here has been aligned. And certainly our office holders and our members in voting in Congress and in their public statements and in the platform of the Democratic Party have not been aligned with striking down this limit. To answer the question directly, I think that the reason why there is a difference here might stem from the fact that the RNC is not in this case. I mean, the fact is the Democratic National Committee spends an enormous amount of money and energy on party building, on registering people to vote in states like Indiana and Missouri when there is no competitive Senate or House election in Indiana or Missouri. And what this is going—
Put aside the question of the RNC and why they're not here. How is your client hurt by, how would your client be hurt if this provision were held to be unconstitutional? I assume you think so. So why?
Right. So, Your Honor, what I was starting to say is that the National Committee in particular, but all of the national parties, but the National Committee in particular and state parties, they have to do party building day in, day out, year in, year out. They have to build the next generation of candidates. They have to register voters in all 50 states. There's been a lot of press about the Democratic National Committee's 50-state project and its expansion. And what that means is that you are investing your hard money not just in the next swing state election, not just in the next competitive election, but in building for the future. What this will do is create a collective action problem that will drive the parties inevitably to just being bill payers. They will not be able to do, they will not be able to support activity that is long-term in nature because there will be an arms race that right now doesn't exist. The coordinated party spending limits act as a buffer on how much money you can pump into directly paying the bills of a House or Senate campaign or a presidential campaign so that you have funds to do these other party building functions.
So that's actually